Hey guys, it's me again from the Law Academy. Here's part 2 of equal protection. Like we talked about before, equal protection has 4 parts. Once you've analyzed which amendment to apply, what class of people is alleging the discrimination, and third, whether the discrimination is facial or neutral, then it's time for step 4. This step is where we determine whether the state or federal law satisfies any of the 3 levels of scrutiny. Here's how it works. When a court decides whether a federal or state law violates the Constitution, it applies any one of 3 tests. We call these tests the 3 levels of scrutiny. The 3 levels of scrutiny are strict scrutiny, intermediate scrutiny, and the rational basis test. Whether strict, intermediate, or rational, here's what the test is looking for. The purpose of the test is to determine if the law is constitutional or unconstitutional. Every law consists of 3 components: the class it regulates, the goal of the law, and the method or means by which the law achieves its goal or purpose. Let's look at each component separately. Depending on the class being regulated, the court will use a hard test like strict scrutiny for a suspect class or group, or an easier test like the rational basis for a non-suspect class or group. Identifying whether the class is suspect or non-suspect helps to determine which level of scrutiny to apply. You'll usually apply at least 2 tests because each party has their preferred test based on the outcome they want. Now let's look at the second component. Again, a federal or state law has a goal. If the court looks through the lens of strict scrutiny, then the goal of the law must be to satisfy a compelling interest. This is such a hard test to meet that not even the U.S. war with Japan was considered a compelling enough reason to justify placing Japanese Americans in internment camps. Also, the test favors challengers because the burden of proof is on the government and not the challenger. Of course, the government would prefer that the court examine their goal through the softer lens of the rational basis test. Under this test, government's reason for creating the camps would be enough to meet constitutional scrutiny if it were only rationally related to a legitimate end, such as protecting public safety. Then there's the intermediate scrutiny. If the court were to apply intermediate scrutiny, then the goal of the law must be substantially related to an important government end. An important government end is something more than a mere legitimate end, but still not as stringent as a compelling end that's required under strict scrutiny. So let's look at the third component. The same as you must take steps to achieve a goal, a state or federal law must have means to achieve its end. Under equal protection, the means of a state or federal law must also satisfy any 3 of the applicable levels of scrutiny. Let's say that you have a state or federal law, and its purpose or goal is to prevent terrorism. The method that the law uses to achieve its end goal is called the means. The means of a federal or state law to reduce terror attacks may be narrowly focused on that end goal if it required all people to go through a security checkpoint screening. On the other hand, the means of a law may be too broad and under-inclusive if it were to only require Muslim and Arab people to go through a checkpoint screening. The reason is this: a law targeting people on the basis of race or religion paints with too broad a brush, whereas a law that requires everyone to be screened is narrowly focused on the issue of terrorism and not the race or religion of a people. If Muslim Americans sued on the basis of this law being discriminatory, they would want the court to look at the facts through the lens of strict scrutiny, because it would require that the checkpoint screening means be more narrow and that there be no less discriminatory alternative. Since screening all people would be less discriminatory than screening only Muslims or Arabs, this law would certainly fail the strict scrutiny test. Of course, if this law were put in place by the state or federal government, they would prefer that it be subject to the lower scrutiny of the rational basis test. Unlike strict scrutiny, the lower rational basis test standard would be more easily satisfied since the means of the checkpoint screening is based on a legitimate purpose, such as protecting public safety. The government also prefers this lens because the burden of proof is on the challenger and not on the government. You see, the rational basis test basically is differential to the government. Lastly, if intermediate scrutiny were applied, then the checkpoint screening means of preventing terrorism would have to be substantially related to an important government interest. The intermediate test is a bit more lenient than strict scrutiny, since under the strict scrutiny test, there must be absolutely no less discriminatory alternative. Also, finding an important government interest for the screening is easier than finding a necessary and compelling interest, as is required under the strict scrutiny test. Although not as tough as strict scrutiny, challengers would still prefer this lens rather than the rational basis test, because, like strict scrutiny, the burden of proof is still on the government. So here's the big picture. On an equal protection outline or exam question, your role is this. First, figure out whether to apply the 14th Amendment or the 5th Amendment based on whether the action is being taken by the federal or state government enacting a law. Second, determine whether the state or federal law is discriminatory against a suspect class or a non-suspect class. Third, examine whether the discriminatory law is facially discriminatory or facially neutral with a discriminatory impact and purpose. Fourth, make arguments as to whether the means and purpose of the federal or state law satisfy the various tests for the levels of scrutiny. That's equal protection. Now that you have this systematic approach, get an early start outlining and taking practice exams.